Good morning. It's Bernard Nomberg with the Nomberg Law Firm. We're back for another Tuesday edition of our Talk on the Law. This morning we have my good friend Sid Summey with the law office of White Arnold Dowd. And Sid is, if not the foremost expert in probate and conservator work in Alabama. I dare you to find somebody who's more informed. Welcome, Sid, and I appreciate you being here.
Thank you. It's good to be here.
Tell the folks who may not know you who you are, what you're about, and inform them a little bit.
I'm a partner here at White Arnold Dowd. We're in Birmingham, downtown Birmingham. I serve as the county conservator and guardian, sometimes called the county fiduciary, for Jefferson County. It's not a paid position. I'm just appointed by the probate court here should there be a need for someone to be the person who's responsible for the funds of someone who has lost their capacity, for minors who can't handle their own funds but maybe come into some, and also to serve as guardian to make life decisions for people who again may have dementia or some form of confusion associated with aging, more than I am, and need help with that sort of thing. So the law sometimes takes over and does that, and I'm the person that's appointed if there's no family member or if there's no other arrangements that have been made by the person involved.
And Sid, I brought you on today because of your expertise in probate and conservatorship laws, which are really such a unique set of laws. And I know that a lot of times when you deal with folks, it's during an emotional time period. It's dealing with loved ones who are either having problems making their own decisions, or their doctors have advised the family members. Talk just a little bit about that in general. We'll get to the needs of what you see for folks per decade as they age, but talk about that. When do you usually come into a situation with folks who may need your help?
A lot of times I'm appointed when it's really gotten too late. I've gotten a number of people who have called me before and said, I'd like to, I think my aging father needs to sign a durable power of attorney, but because he's lost his ability to transact his affairs. Well, it's too late when that's done. So what happens then is there has to be a petition in the probate court, and the court appoints someone. It's a very complicated process, and it's cumbersome, and it's expensive. I make my living as a conservator, but I'm here to tell you that it's a very cumbersome and expensive way to handle the affairs of someone who can no longer do that for themselves.
Now, your office is physically based here in Birmingham, but I assume you have cases, if not throughout the entire state, most of the state, or tell us a little bit about that.
Yeah, I do. I was just in Tuscaloosa yesterday in a case that involved these issues. It was in circuit court. So I do go around the state. In the past, I've gone around the state a lot. I'm busier and busier in Birmingham and Jefferson and Shelby County, so I tend to stay here more now. But we do get out from town. The laws are a little different. In Jefferson County and Shelby County, the probate judges must be lawyers, and they have the same authority that a circuit judge has. In some other counties, they don't have to be lawyers. They're usually very knowledgeable in conservatorship and guardianship law, but their jurisdiction is a little bit limited, so sometimes cases get removed to circuit court.
Okay. Let's talk a little bit about, from a planning standpoint. Let's start, I guess, someone who's in their 20s, let's say they're out of college now and they're about to get married, they don't have children. From a planning standpoint, what do you advise your clients?
Yeah, well, if you don't have children, sometimes that can be even more of a concern in terms of death planning. That is, we're all going to come to an end, and you must plan where you want your estate to go. If you don't make a plan, there is an intestate succession that will happen. Interestingly enough, if you're married and have no children, and your estate, your probate estate, exceeds $100,000, your spouse will get the first $100,000. But if you have a living parent, your parent gets half of everything over that. A lot of people don't know that. Again, this sort of goes back to the agrarian times when we're talking about the family farm. So,
now, is that for someone who does not have a will?
That's for someone who doesn't have a will.
Okay.
The way you can avoid that, of course, is to have a will. There can be a very simple will for an unmarried couple. I mean, a married couple that have children or don't have children. You can also plan if you have children, and that gets to be much more important. I'm too old to have a 10-year-old, but I do. And should something happen to me, I'm apt. Most of us are, having kids later, and we're apt to have a better estate, a larger estate, and it might need some management. If I leave money to a 10-year-old, it's going to have to go to a conservatorship, but I can leave it into a trust, and I could have some trusted person to manage those funds for him. Of course, in this case, my wife would do that, of course.
Sure.
But you can pick the person you want to manage the funds, and you can make a lot of arrangements in a will, even as a young person. And more we're dying with being worth more than we used to. But we've got 401ks that build up. Now, some of those are non-probate assets. We designate who we want them to go to, but for the most part, making some plans is a good idea, even for a young person. The other thing, we talked about losing your capacity to handle your affairs. A general durable power of attorney is the way you decide who you want to handle your affairs should you not be able to do that anymore. And I've had situations where you don't have to be very old. I've had brain injuries of 40-year-old people who thought they were going to live to a ripe old age, as we all do, but they find themselves not being able to handle their affairs, and they didn't make arrangements for it. So you can do that with a durable power of attorney. You can also do it with trust. There are living trusts, and some people like to put their property in these trusts, and they can be their own trustee until they can no longer serve in that capacity, and you give a lot of authority to a trustee to make financial decisions.
Sure. Tell us, when do you advise for folks to make changes to any wills or trusts, et cetera, during their lifetime as they age into their 30s and 40s and 50s, as life changes with children and et cetera?
I have a theory that our lives change with every decade, and that's a good benchmark. I tell my clients, give me a call. Tell me what's going on. You can do it every year. You can do it every 5 years. You can do it every 10 years. And I don't charge for that call. I just say, sure, tell me what's up. And if you've had an inheritance, if you've had a child, if you've had a child that suddenly has some special needs, if you have a parent that has become in need of some special care or planning, then we all can't have granddads that can play pitch at 100. I saw a video of that. It was wonderful. It was touching to me. But in any event, you can have a quick conversation with whether that is an event that requires some more looking. Sort of like you go to the doctor once a year and you look around at things. I'm a light-skinned, freckle-faced guy, and I look at these freckles, and if they start looking cancerous, I go run to my doctor, and fortunately they don't. The news is good.
Sure. Let's talk about as the population seems to be getting older, the average lifespan is increasing each decade. You see the new statistics. Does that factor in probate and estate planning as people are getting older? They're retiring, they're living longer, their needs may change. Talk a little bit about that.
Yeah, it's amazing. Lifespan used to be 72 for males, and now we're easily living in 90s and 100s, and that requires some planning. My own father-in-law is turning 90, and he's out looking for the right spot for him for his next chapter, instead of living in his large house in the country. And it's great that he can do that, and we all should. He's looking at it from a very realistic, pragmatic point of view instead of avoiding the topic, and that's a great idea, so he can make choices for himself instead of having those made for him. So that's something. It's a hard subject to broach with your parents as they get older, but it's great to sit down and have that conversation while they can have a lot of input, and so that you're not making a decision for somebody else. And there's a lot available now. There more and more demographically, as you said, we're living older, but we're also in need of some assistance. But there are facilities available now that are not the old idea of putting you in the home. It's I visit nursing homes every week, and there are a lot of them I wish they'd take me because it's a great place to live, great place to stay, good meals, good activities, and nice accommodations.
Sid, it's all fantastic information, and we appreciate your expertise, your knowledge, and knowing that you're based in Birmingham. I want to ask you about, do the laws of Alabama and the documents that you create here for your Alabama-based clients, do they have, if somebody moves out of town, out of state, do those documents still apply in other states? How does that work?
Yeah, they pretty much do. We in Alabama follow the Uniform Guardianship and Protective Proceedings Act, which is a uniform act that has been adopted by a lot of states. Actually, I'm sitting on a commission. We're going to review a new version of it for Alabama. That's in the works. But for the most part, states, these kinds of documents and planning documents do cross boundaries, state lines. It's always a good idea if you change states to contact a lawyer in that state, have them take a look at it. I get people that call me all the time and say, I just moved here from another state, I want you to look at my will. And I take a look at it, and easily 9 times out of 10 I say, if it does everything you wanted it to do when you made it, if that's still your desire, this will is as good here as a new one would be. So the only difference is if you have some problem in finding witnesses, should they be necessary, they could be out of state. It's a long way. You might re-execute a similar will.
Do other states, to your knowledge, also have the self-authenticating will process that we do?
Yeah, we have what's called a self-proving will, and if you make a certain acknowledgement in front of a notary public, you and the witnesses, then it's self-proving, so you don't have to call those witnesses in. Most states have that now. That's one of those uniform acts that travels across state lines pretty well. Some states require a little more witness than others, so sometimes it's a good idea to, we add an extra witness on. We add witnesses to deeds sometimes because in Florida you can have an acknowledged deed, but it also has to have 2 witnesses. In Alabama it doesn't, but just a few of those minor things.
Now, all of these documents we've been talking about, or you've been talking about, wills and powers of attorney, durable documents. Is that what your firm, you guys handle those here?
Yes, we do. We do that, certainly, and we take appointments from the court as well. I want to put in one quick word to be very careful. I've often said that a durable power of attorney can be the most effective burglary tool there is. There are trusted family members, and as we age, we cease to sometimes be wary of others, and particularly if those others are in our own family. We just know to trust them. And sometimes there are family members that are not so trustworthy, and will use that authority to do something that is maybe in their own interest, but not in the interest of the person they're serving. So you have to be sort of careful about that. Usually, I would say, get all your kids involved in the decision making. Be upfront, share information, so that there's not a family squabble later.
And there usually is, no matter how good the planning is.
Yes, there can be a lot of family squabbles.
Well, Sid, this is all fantastic information. If folks in the future want to contact you about probate and estate planning and documents, etc., please tell them, how do they get in touch with you?
Well, I'm here at White Arnold Dowd, and actually we have a website, which is www.whitearnolddowd altogether, which is WHITEARNOLDDOWD.com, and you can find me there, my contact information and my phone numbers here.
Okay. Sid, thank you again. We sure appreciate your time and
Total
expertise.
Pleasure. Thank you.
Thank you for spending a few minutes with us. I'm Bernard Nomberg with the Nomberg Law Firm. This is our usual Tuesday morning talk on the law. We'll be back next week. Hope you guys stay dry. It's been a terribly rainy day here today, but have a good rest of your week. Take care.